And we're going to resume with her being questioned by the department's attorney, Ms. Headley.
May I proceed?
Please.
Thank you, President Bach. Ms. Schanning, can you take what's been previously marked as D12 for me? Can you take a look at that document for me?
Yes. Do I need to be resworn or am I still sworn?
Great question.
I was.
President Bach, do you want the witness to be resworn or is she still under oath?
Oh, I felt that she was sworn in.
No objection.
Thank you.
We agree.
So
Okay,
let's proceed.
thank you. So Ms. Schanning, can you please place in front of you Exhibit D12?
Yes.
Um,
Let me get the D12.
Certainly.
Yes.
Yeah, so to counsel that, were you aware of the fact that he was charged with misappropriation of a personal identification to obtain value or benefit, which is a felony charge?
I was.
I'll represent to the commissioners that this is the Criminal Justice Information Services Security Policy, a rather lengthy 377-page document. Ms. Schanning, did you, I'm sorry, Commissioner Cleary, are you ready for me to ask questions or?
Just got there.
Okay,
Yes.
excellent.
I was.
Ms. Schanning, did you review this as a part of your due diligence when determining whether Mr. Young could perform his essential job functions?
Yes. So when I received the CJIS audit questionnaire and found the questions that I had previously testified to as being of concern to me, I did locate this security policy from CJIS. I was able to obtain it online. As you can see, it is extremely lengthy document, so I did not review it in its entirety. However, I did try to go through and pinpoint those sections that were applicable to the areas of concern, and I did review those sections.
And when you reviewed those sections, did you make any highlights on a particular document?
I did, because I had gone back to this a number of times and realized very quickly that due to the length, it was difficult for me to go back and remember which sections it was. So at one point I did do highlights so that it would be easier to locate those sections for future reference.
Was that the document that was submitted to this commission as DU1A?
Yes, and in fact, I submitted that because at that time, we were unaware that Mr. Young had an attorney, and as the acting HR director, I was going to present the case to the commission instead of Attorney Headley.
Thank you. Turning to page number 144 of that document of D12, commissioners, on the PDF, that's going to be page 166. But on the physical document itself, it's page 144.
Thank you.
Yes, you there? Okay. I'll direct your attention to that, the policy 511, formal audits. If you look at the second paragraph there, 511.1.2.
Yes.
Do you recall there being, or do you recall reading this document or this provision when rendering your decision?
Yes, I do.
Okay. And does this provision of the document indicate that systems will be audited once every 3 years at a minimum?
Yes, and in particular, I reviewed this section because I was questioning whether an audit had been performed during the time that Mr. Young had been holding this position, such that this issue would have come up previously.
Okay. And when you reviewed that, did you come to learn whether an audit had previously been performed while Mr. Young was employed as a city in the office of city attorney?
Prior to the 2024 audit, the most recent one was in 2021, prior to Mr. Young being hired.
And Mr. Young, again, began employment with the city attorney's office when?
February of 2022.
So just to be clear, the 2024 audit was the first time that an audit had been performed during Antoine's tenure?
That is my understanding, yes.
Okay. Do you know if, in addition to this particular policy that we've discussed in length with AC Sarno before you and then you a little bit here now, and that you reviewed, in addition to this policy, is there any other particular contract that governs the Office of the City Attorney as it relates to accessing CJIS information?
Yes, I am aware that there is an agreement between the city attorney's office and I believe it's the Wisconsin Department of Justice, which operates the program locally here. That had to be signed, and I believe the most recent one was signed following the 2024 audit. Prior to that, the more recent one was 2021.
Is it your understanding that these contracts come triannually with with an audit?
That's my understanding.
Okay. In this contract that was signed in 2024 and previous years, does the provision, does the contract have a provision about the misuse of CGI information?
It does.
Does the policy, does the contract indicate that in the event of discovery of misuse, the undersigned criminal justice agency agrees to take corrective administrative action or lose the usage privileges?
Yes.
Okay. And when you review that, what do you understand that provision of the contract to mean?
I understood that provision to mean that we would have to take corrective action as soon as we learned of the fact that Mr. Young was given access to our OED office and the computers on which the CJIS databases were located, and that action would be to remove him from that access.
I'll turn your attention now to questioning whether or not, or we'll just ask a question. If an assistant city attorney could not pass CJIS, would that assistant city attorney be able to work at the Ordinance Enforcement Division?
No.
Why not?
We need those assistant city attorneys to have access to those databases, and if they can't pass the CJIS background, we would not be able to use their services at that office. They would not be able to perform the job.
Same question with a legal office assistant or other support staff.
Same answer. The reasoning there is because of the need for access and the fact that the CJIS policy does not even allow access to the areas where those computers are kept. We would not be able to have support staff working in that office if they didn't have CJIS clearance.
Does that mean that they would not be able to work for the Office of the City Attorney at all?
No, we could still place them in our main office in the Zeidler Municipal Building. We do not have any access to the CJIS databases there.
And why couldn't you do the same thing with Mr. Young?
The difference is that the attorneys and the rest of the support staff can have their work compartmentalized so that they are only working on things in that office. As part of Mr. Young's duties, he had to support the IT needs and the computers of all of the staff in the office. So in both offices, as we discussed in my testimony yesterday, the job description does require the IT person to be able to work in both of our offices.
If you turn to Exhibit A18, that's A18, the 5-page job description dated April 26, 2024. Is there anything else? Is there any other job description or essential job functions that Mr. Young could not perform?
Well, as we talked about yesterday, we already mentioned the inability to work in the Office of Ordinance Enforcement. But as I reviewed the job description and determining whether or not Mr. Young could fulfill his duties, there were other things that stepped out at me as well. Under the first section of essential functions, the 50% sections, the fourth bullet point, there is mention of monitoring the department's compliance with software application license agreements. I read that to include the agreement that we have for the CJIS databases. I did not feel that if Mr. Young was himself not in compliance with that agreement, he would not be able to monitor adequately the department's compliance, as he in fact was the reason we were not in compliance.
Anything else?
Yes, on the next page, let me remind myself which ones I also had concerns about the 5th bullet point from the top, discussing management of network security. Again, a lot of the CJIS policies have to do with security, And given the lack of CJIS clearance, I was concerned about that. Under that same section, just read through this. Under that same section, the final bullet point talks about audit issues and resolving any deficiencies. This jumped out at me because we were facing the CJIS audit. Given that Mr. Young himself was our deficiency in that he didn't have clearance, I did not feel that he could adequately meet that job job function as well. And then I think the other issue we had discussed yesterday, was there another? Yeah, the under the 10%, the final bullet point about the specialized software in the OED staff office.
Is it your testimony, or do you believe that Mr. Young was performing all of his essential job functions when you were his direct supervisor?
No. Once I became aware of the CJIS clearance issue and the policy that we were not in compliance with, he was not functioning, meeting all of his job duties.
All right. Turn your attention to Exhibit A1. That's A1, single page document, termination during probation notice.
Yes.
You reviewed this document in prepping for today's hearing.
Yes.
Prior to your rejoin, I'll ask it like this. Did you have any direct knowledge? Do you, as you sit here today, have any direct knowledge as to what Ms. Jackson was thinking when she drafted this termination notice?
No, I could not think inside Ms. Jackson's head.
Were you provided any other information regarding this termination?
The only thing that I was provided was what I was able to locate in Mr. Young's employment file as the acting HR administrator. I did review that file. As I mentioned yesterday, I found this probation notice as well as documentation referencing the background check that was done. And then also, I believe there was documented, actually, it wasn't in the personnel file. I believe there was emails in the HR administrator email account noting that Mr. Young was then rehired on May 24th, I believe, of 2022.
And you have no idea as to why Mr. Young was rehired?
I do not.
Is there anything else that you wish the commissioners to be aware of as it relates to your involvement in the separation of employment of Mr. Young?
I don't believe so, no.
At this point in time, I have no further questions for this witness.
We'll have a cross-examination, and then the commissioners will have the opportunity to also ask you questions.
Are you ready?
I am.
Okay. When did you become Mr. Young's supervisor?
I don't remember the exact date, but I returned to the office in early May of 2024, and it was shortly after that that City Attorney Goike asked me if I would take on that supervision role.
Okay. But not in April, right?
Correct.
Okay. And how did you inform Mr. Young that you had become a supervisor?
I believe, I don't know that I informed him. I believe that City Attorney Goike, who had one-on-one meetings with each of the staff members after he was elected, may have informed him of that.
Okay, so it's fair to say you don't know.
I don't know.
I mean, you didn't do it.
If I did, I don't recall specifically.
Okay. Is there anything that you may have done to communicate to Mr. Young that you were his supervisor?
It was made, we did do kind of an office, I don't want to say organizational chart, but a list of what the different sections were, what the deputies' responsibilities were, and who people supervised, and it
Okay.
was noted on there.
Great. Now, Can you, when you say we did this, and going forward, it'd be helpful if you just tell me the names here.
Sure.
If you're able to do that, that would be helpful. When you say we, who are you talking about?
I'm talking about the city attorney and the 4 deputies.
Okay. And so how do you know that this was communicated to Mr. Young at
It was sent by email to all staff.
all? Okay. And you believe that that communicated to him that you were his direct supervisor?
Like I said, I believe he was made aware of that prior to that, but I don't know if that was through Mr. Goike or through myself.
I understand. My question wasn't about what you had said earlier. My question was specifically about whether or not you believe that that communicated to Mr. Young that you were his supervisor. Can you please answer that question?
Yeah, I believe that he was aware of it before that went out, but if there was any confusion, that certainly cemented it.
Why do you think that it was cemented at that?
Because he was listed under me as part of the staff that I supervised.
Okay. And I believe you mentioned yesterday that you supervised other employees other than Mr. Young.
Correct.
Okay, who was that?
I supervise 7 assistant city attorneys. I
Okay.
am also the supervisor for the HR administrator,
Okay,
the finance director for the office. I believe that's it.
okay, HR admin, what's that person's name?
Currently, it's Lisa Gilmore,
Great, what was it before that?
Sharon Cook,
Okay,
Sharon Crow, sorry.
Lisa Gilmore, that's the attorney that used to work for the city attorney's office?
Correct.
Okay. And Cheryl Crow, is that what you said?
Sharon Crow,
Sharon,
yes,
with an N.
not the singer.
Got it. Okay. And do I understand you correctly that she no longer works with the city attorney's office?
That is correct.
Okay. Do you know about when she was separated from the city attorney's office?
I believe it was in December,
It was in December.
yes,
Similar time to, same month as Mr. Young, true?
correct, similar time.
Okay. And was she ever placed on administrative leave at any time?
She was.
Okay, and just in conjunction with Mr. Young, can you explain that to me, how those may or may not have overlapped?
I believe it was a similar time frame.
Like in the same day, right?
Possibly, yes.
Okay. Is that a coincidence?
Just a circumstance.
Okay. So then let's back up. At some point, I understand that you had received, or you had formed the opinion that Mr. Young should be placed on a PIP. Did I understand that right?
I had not decided that. I was considering that because I was getting a number of complaints about his performance.
Okay, and to be clear, you were considering forming the opinion, or you were considering whether to put him on the PIP?
I was considering whether to put him on a PIP.
Okay, was there ever a time when you had decided to place him on a PIP?
I had talked to the city attorney about moving forward with that,
Okay,
and possibly scheduling a meeting with him, but we did not do that.
oh, okay. And do you have the authority in and of yourself to place Mr. Young on a PIP?
I would not do that without consulting the city attorney.
Okay, does that mean you do not have the authority or something else?
I may have the authority, but I would consult with the city attorney.
Okay. And how about DER? Would you consult with them?
I would consult with them not to get authority, but to ask for assistance.
Okay, and when you consulted with DER, what assistance did they give you?
With regards to what?
Well, Mr. Young, are we here for something else?
Well, are you talking about a PIP or about the termination? Your question is unclear to me.
Oh, okay. So how many times have you discussed Mr. Young with DER?
I don't have an exact number.
Okay, and when I say DER, is it fair to say we're talking about Harper Donahue or somebody else?
Harper Donahue, I did have one conversation with Kristen Urban.
I'm sorry?
I did have one conversation with Kristen Urban.
Okay, and I may not be familiar with that last name. Could you spell it, please?
URBAN.
Thank you. Okay, and what position does she hold?
I don't know her title. She's right there.
Okay, I'll take your word for it. What was the purpose of that conversation?
I was having a meeting with her about another employee that I was placing on a PIP. And I just had mentioned to her that we were considering doing one for Mr. Young and that I would be reaching out again for assistance when that time came.
Okay, and who is the employee that you were placing on the PIP?
I would rather not reveal employee confidential information.
I understand. Can you please answer the question?
I'm going to object as to outside the relevant, out
Well,
of the scope here.
how is this relevant, Mr.
Well,
Hitchcock?
so first of all, I think there's a contention that she didn't have time to place Mr. Young on a PIP.
No, I
But
don't think she said that.
Miss,
I think there's the contention. I said, I didn't think she said that testified to that. I guess my
Oh, that's your
question,
contention.
sure, my question is, why is this not relevant? And why, if this is happening, for example, is this not, Sharon Crow here? Because that I think is who we're talking about.
Mr. President, if I may. Employee disciplinary data is a category of data that is subject to increased privacy protections under state statute. And notably, it justifies closed sessions in certain instances. So I think when the commission is balancing whether or not to reveal a particular name of an individual versus the fact that there was a general individual, that fact should be taken into account.
Well, just to be clear, we didn't have, even though you had asked Ms. Headley not to go over my client's conviction record in great detail, Ms. Headley went over my client's conviction record in great detail on television. So if we need to go into closed session, then by all means, let's go into closed session. But if there's a PIP that's going on, and I think it might be relevant here to what is at stake, which is whether or not this discipline was reasonable.
Well, but you're talking about some other employee, not Mr. Young.
True.
She was considering a PIP approach for Mr. Young for for performance-related reasons. But it ended up getting sidetracked by the issue regarding clearance access.
Mr. Bach, if I may, if the question is whether or not there was adequate time to put Mr. Young on a PIP, just ask the question.
No, I'm not. The question that I'm asking is, was Cheryl Crow the person that was put on the PIP? That's the question that's outstanding.
And again, I'll register the objection that that is not relevant to the proceedings here today.
Because we're not going to the issues that PIP was being considered for. We're going for the clearance access issue, which is what the separation is about.
Well, again, with respect, we have our other opinions as to what may be accurate. I appreciate that you're giving us that advice on what we should be focused on. The question, I mean, there's really no reason to not give out this person's name other than to, in theory, protect somebody here. The real question is whether or not this is going to help us answer the question here. I guess we'll have to go around it another way. I'd like to get it clear that you're not allowing us to answer this question.
That's correct. At this time,
Okay.
I'm not allowing the going into whether or not some other employee was on the PIP for performance related, which PIP stands for performance improvement plans for some performance related issue. This case involves Mr. Young, and it's not about any performance improvement plan. It's about his not being approved for clearance access to the security system. So it's not about his performance, which may or may not have been it sounds like a medium-sized issue, not a major or minor, but it got put aside because of a much more significant issue from the point of view of the department.
Right. And so that's why I think you have correctly encapsulated what their assertion is. And so now we are trying to test the validity of that assertion. That's why we're asked, that's the whole point of cross-examination here. So if we're, again, sir, if we're just
going into people's performance issues doesn't provide any clarity for the issue before us today.
I don't have any intention of asking what the performance issues are. I don't need to know anything more about what, except for whether, who this person was. That's
I
the only
believe-
thing that we've asked.
I'm sure we could go in circles about this all day, but the commission has made a ruling that the name of the individual that was the subject of the PIP is the forcing the witness to reveal that name has been denied.
So, Ms. Schanning, when did you have this conversation with this DER employee?
I want to say late summer, early fall.
Okay. Before October?
Yes.
Okay. And when did you talk to Mr. Donahue?
I don't recall.
Okay, how many times did you talk to Mr. Donahue?
Prior to, are you asking me about the performance improvement plan for Mr. Young, or are you talking about the potential termination of Mr. Young?
How many times did you talk to Mr. Harper Donahue about Mr. Young?
Approximately 4 times.
When was the first time that you talked to
I would say early fall, maybe September.
him? Okay, when was the second, what was the purpose of that conversation?
Mr. Young had talked to Harper Donahue about an employee in our office and an interaction that he had with an employee in July.
Okay, and who was that?
Naomi Sanders.
Okay, so you're okay to name that name?
This is not about her performance.
Got it. Okay, so what was the complaint about Ms. Sanders?
That she had yelled at him.
Okay, and what was the outcome of that complaint by Mr. Young?
The complaint, when it had happened in July, went to the city attorney. He spoke to both parties and cleared the air. And
Okay,
then in September, or I think September, Mr. Young went to Harper Donahue to bring it up again.
I got it. And you supervised Mr. Young at that time, right?
I did.
Okay, and did you talk to Mr. Young about his complaints at all?
I did not, because the city attorney had.
Okay. Did you talk to the city attorney about Mr. Young's complaints anytime?
The city attorney did mention that to me, that he had talked to both parties and that he felt it was resolved.
Okay. Did you ever directly told Mr. Young that you were his supervisor?
I'm gonna object to asked and answered.
Well, I'm gonna let her answer as she sees appropriate.
I don't recall a time when I went up to him and said, "Hey, Antoine, I'm your supervisor."
Okay.
But I do believe he was aware that I am his supervisor.
Okay. And was that based on any information that anything that he had said to you?
Are you asking if he came to me and said, "I know you're my supervisor"? I guess what kind of things are we asking
No, I
about?
got the question that I asked was simply this. Is your belief that Mr. Young was aware or believed that you were his supervisor based on anything that he had said to you?
Um, Nothing that I can recall off the top of my head.
Okay. And as a supervisor, you would have been called on to do performance evaluations for Mr. Young, right?
Correct.
Did you do any of those?
We have not done any performance evaluations in our office since the city attorney took
Okay.
office.
And can you turn to A18, please?
Yes. Okay.
Now, you're aware that this is the sole document that the city has provided that shows that you may be the supervisor over Mr. Young. Isn't that true?
The sole document we've provided here, or?
That's right.
Well, I believe that I'm also listed on the termination paperwork. Whether that specifically says that I'm the supervisor is, I don't recall, but
Okay. And so, and can you look at the top here?
yes.
And actually, I'm going to direct your attention to where it says immediate supervisor, Mary Schanning, chief deputy. That's on C on page 2. Do you see that?
Yes.
Okay. And you testified to us that you started when?
Early May of 2024.
Okay. And can you explain for us how this document prepared in April of 26, approximately 8 days after the city attorney was placed in his position, names you as the supervisor of Mr. Young when you hadn't started at the city attorney's office
I
yet?
cannot explain that.
Okay. Now, can we go back to Mr. Harper Donahue? I understand that there was, and I may be getting the terminology wrong, that there was basically a pre-discharge, disciplinary conference with Mr. Young.
Yeah.
Is that fair?
That's correct.
Did you talk to Mr. Harper after that?
I don't recall.
Okay, you talked to him before that. Is that fair?
Probably, yes.
Okay. And there's also another meeting that happened before Mr. Young, immediately before Mr. Young is put on unpaid leave. Is that true?
Correct.
Okay. Did you talk to Mr. Harper Donahue before that or after that?
I don't specifically recall when I spoke to Mr. Harper Donahue.
Okay, but you recall, because so far I think we talked about one incident, there's two more, is that fair?
Yes.
Okay, so you don't know when those happened, fair?
I can tell you this generally. I don't have exact dates.
Okay,
We spoke, I and the city attorney spoke with Harper Donahue when we learned about the CJIS audit and the concerns with Mr. Young holding the position due to his background. At that point in time, we discussed with Mr. Donahue whether, as we believe, termination would be appropriate. Mr. Donahue asked us to do a bit more due diligence, which we did. I personally dug into the law a bit more, dug into the City Service Commission rules, looked again at the CJIS policy, and then presented, I believe via email, a summary of that to Mr. Donahue to show that we had done the due diligence and had done the background to make sure that we were on good standing.
and that's the email that you sent.
Correct.
And can you provide that to us?
I do not have it with me.
Oh. And you haven't presented to this commission?
I did not.
Okay. And do I understand that there was one time that you talked with Mr. Donahue with the city attorney's office, the city attorney rather, and then another time by yourself, or did I misunderstand that?
I recall at least one time that the city attorney was present in the room. The other communications were either by email or via Teams virtual meetings, and I don't recall whether the city attorney was in on those.
Now, when you testified yesterday, I think you testified that you supervised Milwaukee Public Schools. Do I get that right?
I supervise the assistant city attorney who represents Milwaukee Public Schools.
Oh, okay. Now I understand. Do you supervise the OED?
I do not.
Okay, who does?
Deputy City Attorney Julie Wilson.
Oh,
I will say that when I started with the office in May of 2024, I was initially the deputy over the office or over the section that includes OED, and I remained there until July when Julie was sworn in as a deputy.
so in November, on November 11th, you were not supervising there?
Correct.
Oh. And while you were supervising OED, you ever learned that Mr. Young, how Mr. Young was gaining access to that location?
I was aware that he had to be escorted into the office by Mary Lyles, who is one of the support people at that office.
Great. When did you become aware of that?
I became aware of that when I first started.
Started or something?
When I restarted in May of 2024.
What did you do about that information when you first learned?
I did not do anything with that information when I first learned of it.
Okay, you didn't finish it.
Um,
Can I have you
I don't-
repeat the
I don't
question?
Sure.
I'm sorry. Repeat the last
Did you
question.
tell- Of course, ma'am. This is Ben Hitchcock Cross again. Did you notify the city attorney that you had learned that Mary Lyle was escorting Mr. Young?
I don't believe I did.
Okay. Is it possible that you did?
It's possible.
Okay.
Excuse me. I just, if it's still a meeting you're having at 2:15, I just wanted to remind.
I
you.
appreciate that. It's at 3:00.
Oh,
I
okay.
told the commission, but I don't have direct access.
Right.
But I do appreciate that information and I do, believe me, there's nothing like being under a court order. Okay. So you may have told him, but you're not sure. Fair?
Correct.
Okay, I got it. And as supervisor though, you didn't do any follow-up, is that true?
At the time, I was not aware of the fact that that was a violation of the CJIS policy, so I
Right.
did not.
Okay. And what did you think of that situation at that time?
I thought it was not ideal,
Okay,
but it was what had been happening.
Did you think that, for example, the city attorney's office could be more efficient if that status was changed?
Yes, I feel that it was inefficient for Mary Lyles to have to do that escorting.
And that's back in sometime before, between May and July of
Probably,
last year.
probably in May when I went through my CJIS background check.
Okay. Now, I appreciate you bringing that subject up. To work at the city attorney's office, all employees undergo a background check. Isn't that true?
When you are hired, you undergo a regular background check, but if you are going to be working in the Office of Ordinance Enforcement, you have to go through a CJIS background check. At that time, I was the deputy over that section, so I underwent it, but not everybody goes through CJIS background checks.
I appreciate that.
I'm sorry, I can't hear you again.
I don't think I'm speaking in the microphone, and I'll change that
Thank
behavior.
you.
I'll just add that these are really sensitive, so the further you move away, the more difficult.
Once you start waving your hands around. Okay. So the question I believed I asked, though, was all employees of the city attorney's office undergo a background check. Isn't that true?
All attorneys or all employees, when they are hired to the city, are supposed to undergo a background check. Yes.
Okay. And that's because the city attorney's office has special data that other departments of the city don't have access to. True?
No, that is true of all city employees. That's a DER policy.
Okay. And is there any special check that you do, that the city attorney's office does over its employees because it has access to special attorney-client privilege information?
Not because of special attorney-client privilege information. The lawyers have an ethical obligation to maintain client confidentiality.
Got it. Okay. So the background check is really, the original background check is independent of necessarily working at the city attorney's office. Is that fair?
Correct.
Okay. And then the CJIS is that, when you got CJIS access, what did you obtain?
What do you mean? What did I obtain? Physically?
Maybe they gave you something, maybe they gave you some information, I don't know what.
I received a badge
Okay,
with my photo on it.
okay,
Also, policies and documents that I had to sign, review and sign about the security clearance.
I got it. And what did that badge grant you?
It allowed me to have access to the police administration building, the city attorney's office in the police administration building. And it was basically just an ID while I was there.
And you could be unescorted, is that fair?
Correct.
Okay. And did you also gain credentials to a database?
I did not, because I did not have a need to use the databases.
Why did you get the credentials?
It's required of everybody who works in the office of, basically everybody who works in the police administration building. And because I was the deputy there.
Thank you, I understand. Okay. So at that time, you learned about Mr. Young being escorted into the area, fair?
Correct.
Okay, got it. So it's also fair to say that this is although you had learned from Mary Lyle in November that Mr. Young didn't have access to CJIS, you were aware at least as early as May, true?
I'm going to object that misstates the testimony.
In November,
That's the testimony that I have from hers when she was aware from Mary Lyle, was, I believe, on
I think it was-
November 11th.
so
On November 11th, I was aware that we had an audit for the CJIS clearance. That's when I learned that there was a concern with the audit, because she brought to my attention that she couldn't answer questions on it because Mr. Young was not cleared. And those were causing concerns. That was what happened on November 11th.
But that's not, in other words, that's the first time you learned of the security questionnaire. That's not the first time that you learned that Mr. Young did not have access to CJIS, right?
That was the first time that, in May, I learned that he did not have access to the police administration building.
Okay.
In November, I learned that that was also a concern because of the CJIS audit.
Okay.
There are two things. There's access to the building and then there's access to CJIS, but they go through the same background check.
And you knew that in May, right?
I knew in May that he had not passed the background check.
You
In
knew-
May, I did not know the implications for CJIS.
Well, you knew that
Repeat the question?
Sure. I'm asking her whether or not you knew that in May, that when you signed the application, that one of the things you were granted was access to a badge and access to that area.
Yes,
And you also knew that Mr. Young did not have that access to that area, true?
I knew that he did not have unescorted access to that area.
So, at some point then, you say that people are bringing to you complaints about Mr. Young. Is that true?
Correct.
And then you're asking them to document those complaints, fair?
Yes, I would say that initially people would bring things to me off the cuff, verbally, and I said that there was nothing I could do about it unless they showed me some documentation.
You asked them to document those complaints, true?
If they had complaints, they should document them. Yes.
Okay, was that before or after you went to DER?
That was well before.
Okay. Was that October of 2024, sometime else?
I would say that it was as soon as I started being his supervisor.
Okay. Let's look at what we have as AU2, which I believe has another number now.
Oop. Okay. A26?
Yes.
That's correct. 826 is the new number.
And is this an email sent by you?
No, this is an email to me
Okay, from whom?
from Catherine Headley.
In October?
Correct.
Okay. And I just want to read there, it says, I don't want to bombard your inbox. So this is the last communication. Do you see that?
Yes.
Is it fair? Was Ms. Headley's description of bombarding your inbox, is that fair?
I'm
I
gonna object that this is irrelevant. Email speaks for itself.
I think everyone understands that, it means multiple.
I know that's what it means. I'm asking, is it fair if that's what happened?
You can answer.
I would say that that's not fair. I think that Ms. Headley was being kind and a bit self-deprecating. The pages of emails that are here are the extent of the emails that she sent to me. I don't know that that would be considered a bombardment. I certainly didn't take it as such.
Okay, got it. And what was the point of her, was this, I guess what I'm asking you, is this Ms. Headley documenting her concerns about Mr. Young as you instructed her to do?
I did not necessarily instruct her to do that, but I assume that's why she sent this to me.
Okay, but did you tell her that you wanted your concerns about Mr. Young documented or something else?
I never spoke to her directly about, she never came and complained to me about Mr. Young. I assume that she heard that from others in the office.
Okay, got it. So it's fair to say at this point in October, it was known that you wanted by the city attorneys that you wanted complaints about Mr. Young documented, fair?
I would say that that's fair. To say that I wanted them, I would say that I told people who complained to me that I wasn't going to take verbal complaints, but that if they had some documentation, they could provide it to me. It's not that I sought it out.
Okay. Will you turn to 812, please?
Yes.
Okay. And I'm gonna look halfway down the page. It's from you to Julie Wilson. You see that?
Yes.
Okay, 913. Julie, Sharon told me that Antoine complained to her yesterday that Tyler took a monitor out after another office and moved it to his office, and then when asked about it, denied doing it. Do you know anything about this question mark? I suspect Antoine will use this as an excuse for not having the computer set up done as expected. Did I read that right?
Yes.
Okay. And this is also part of you communicating to people that you wanted these complaints documented?
No.
What is this?
This is we had a situation, we hired a lot of people in the time since I returned to the office. With almost each and every one, there were issues with the setup of the computer. The management staff, which includes Julie Wilson, was aware of this. And so this was in response to a new employee starting and Antoine accusing that person of moving a monitor out of a different office. And I suspect Antoine will use this as an excuse for not having the computer set up done as expected, was referring to the fact that that had happened with almost every other employee that had started
Right.
during that time frame.
Now I understand. Can you tell us when you became of Mr. Young's criminal record?
When I became aware of it,
Yes.
I was aware of his criminal record before I returned to the office.
Okay, how did you become aware of it?
Because the people that I formerly worked with in the city attorney's office kept in contact with each other.
Okay.
And apparently it became known in the office that he had a criminal record and people were sharing that information and it was shared with me at some point in time.
Great. Who was shared it with you?
I don't recall.
Oh, okay.
We have text strings. There's a number of people on them. I don't recall specifically who stated it.
Okay, but it's fair to say that another city attorney told you, let's ask it another way. Could it have been Robin Potter or somebody else?
Robin Pedersen was not on any of the text strings that I was on.
Okay, so it was
It
been
was
somebody
not,
else.
was not Robin Pedersen.
And is there anybody else you're able to tell us that it's not?
It was not Kate Headley.
Okay,
It was not Pat McLean.
great. Now are you able to tell us what the purpose of this communication about Mr. Young's criminal record was?
Just that it became aware to people that were still in the office that he had a criminal background
Okay,
that included things about fraudulent use of credit cards and theft. And people were shocked that he was allowed to remain as the IT person. I believe I was also made aware at that time that he had been dismissed and terminated, but then brought back to the office.
okay. So when you were asked earlier if you knew what was in the person's mind who had originally terminated Mr. Young, you don't know who was in that person's mind because you don't reside in her mind. Fair?
Fair.
Okay, but you did learn why that decision was made, true?
I don't know specifically why Celia Jackson made that determination. I was aware that Mr. Young's criminal background had become known in the office at some point for some reason,
Okay,
that he had been terminated and that he had been brought back into the office. I don't know anything more than that.
and were you aware that how the office got that info?
I do not know.
Oh, and is that, I guess that's my question is, did you believe at that time that they were entitled to have access to that information?
Quite honestly, I believe some people just looked him up on CCAP.
Great. When you had these conversations with these city attorneys, did you push back at any time and say, hey, that's discrimination against somebody for their conviction record?
I didn't comment on it at all.
Okay, but you're an attorney, is that true?
Yes,
And you know in employment that in the state of Wisconsin, it's illegal to discriminate against employees based on their criminal conviction, is that fair?
I didn't feel that anybody was discriminating against him. They were just pointing out that he had a criminal background.
Can you answer my question though?
Yeah.
Then my question was, were you aware of that fact?
I don't do specifically employment law,
Okay,
but that is my understanding.
but prior to this, prior to the recommending of Mr. Young for separation, you did look into those issues, true?
I did.
Okay. Any other time?
No.
Okay, so it's fair to say your sole familiarity with the law on conviction record discrimination isn't prior to this, prior to the actual termination of Mr. Young. Fair?
I do not work in employment law, so while I may have some general knowledge, the first time I looked up the statute was probably in response to the situation with Mr. Young.
Okay. Do you believe that it's appropriate to discriminate against people based on their criminal record?
I do not believe it's appropriate to violate the law, and if the law says that you can't discriminate, I don't think that the statute specifically uses the word discriminate,
Okay.
but I believe that you should follow the statute.
Okay, and so those comments that you got that Mr. Young shouldn't be at the city attorney's office because of his criminal record, do you think that those comments constitute criminal record discrimination or something else?
Those were not statements that I made, just to be clear. They were statements that people made in passing. Those are not people that could terminate him. They were just statements of, they were surprised that he was allowed to stay.
Oh,
And he was allowed to stay, so there was no, action at that time by the people making those statements that I would think would be discriminatory.
Oh, okay. Well, they said that he should be removed, right?
No, I said they were surprised
Oh.
that he was able to work there.
Surprised that he continued to work there,
Yeah,
true?
yeah.
Okay. Okay. Because of his criminal record.
Yes,
Okay. Did you bring that to the attention of the city attorney at that time?
I did not.
Why not?
I did not work in the office at that time.
Okay. But you were talking with people who did work at that office, but you didn't feel that that information was something worthy to bring to the attention of the city attorney. Did I get that right?
I did not have communication with the city attorney at that time.
Okay. Now, what training have you received in HR management?
I have not received any formal training in HR management.
Okay. How about IT? Any training in that?
No.
Okay. So, when you contacted the FBI, what did they tell you?
I didn't contact the FBI.
Oh, okay, why not?
I have no reason to contact the FBI.
Oh, okay. And you felt that with your IT background, that you understood the CJIS policy completely, is that fair?
I'm going to object to argumentative.
Yeah, that's, she didn't suggest that in any way.
She didn't suggest that she understood the CJIS policy?
No, that IT.
Do you believe that you understood the CJIS policy?
I believe I understood the portions of the CJIS policy that directly relate to Mr. Young's position in the office.
Okay. And did you feel that you fully understood all the IT issues involved in the CJIS policy?
I didn't review the entire CJIS policy as I testified earlier.
I understand that. What you did read, did you feel that you understood?
I did, and I did not review anything that was specific to IT. It was specific to the access that our IT person has, but not specific to anything related to network or security or IT information technology issues at all.
Okay. So can we go back to the job description?
What's the number?
18.
Is it A18?
Yes.
Yes,
And in this document, you were able to tell us, if I recall, why Mr. Young couldn't perform the essential duties of his job. True?
True.
Okay. And were you able to determine that based on his, because of his IT, his access to networks or other things?
This was based specifically on the concerns that were raised because of the lack of CJIS clearance.
Okay. Now, based on your knowledge and understanding, Mr. Young could be work in the OED offices. He just had to be escorted. Fair?
What I know now is that that is not correct. What I understood when I started in the office was I believed that he could work in the office if escorted. But once I became aware of the details of the CJIS policy, I quickly became aware that he could not even work in that office.
And that's your interpretation, true?
That's my interpretation, and it was also Assistant Chief Sarno's interpretation when I discussed it with him.
Okay. Now I understand. So let's back up. When did you talk to Mr. Sarno?
I spoke to Mr. Sarno between the time that I learned of the CJIS audit and before we had the initial meeting with Mr. Young about putting him on paid administrative leave.
Okay.
This was part of the due diligence that I had done at the request of Mr. Donahue. I wanted to make sure I fully understand what the process was for CJIS clearance and to inquire whether we could redo Mr. Young's background check to see if he could pass now, given that 3 years had gone by.
Okay. And you asked Mr. Sarno to be a subject expert for this hearing during that meeting, right?
No. The initial meeting that I had, I did not even mention Mr. Young's name.
Okay.
I was just asking for general information so that I could understand the procedure for getting a CJIS clearance. I, at that point, did not want to specifically mention Mr. Antoine, Mr. Young by name because we hadn't taken any action against him and I wanted to respect his privacy.
Okay. So when did you tell him about Mr. Young?
After we did the termination and Mr. Young filed his appeal, then I specifically contacted him and mentioned that we would likely need him as an expert. And at that time, I asked him if he would confirm whether or not he would still deny access for Mr. Young.
Okay, I got it. But that was after Mr. Young was terminated, right?
It was after we started the process.
Okay. And just so I'm clear, Young was terminated on, I think, December 2nd, true?
We had our pre-discharge meeting with him on December 2nd. He was actually discharged on December 11th.
Okay, and the audit was due on the 23rd, fair?
November 23rd, correct.
Okay, so while you responded to the audit, Mr. Young was not terminated, fair?
He was on paid administrative leave.
Okay, got it. All right, and then, when you talked to Mr. Young, and did you ever find out how he was able to complete his job for 3.5 years?
It is my understanding that he was allowed to be in the position, but the entire time that he was operating within the Office of Ordinance Enforcement in the Police Administration Building, he was in violation of the CJIS policy that the office was required to comply with.
Okay, so let's just back that up there. Can you first just answer my question about what Mr. Young said?
What Mr. Young said when?
When you asked him about how he had performed his job for the last 3 years?
I didn't ask him that question.
Ever?
No.
Oh, okay. And that wasn't something you needed to do as a supervisor?
Again, we had not done any performance evaluations. I was not evaluating his performance to ask him how he did his job.
So you simply determined based on a review of a document that he couldn't do his job, but you never asked him how he was able to perform his job, fair?
I would say that's fair.
Okay. Were you aware of any breaches of any CGI?
No.
Okay. Did you ever investigate for any breaches of CGI?
No.
Why not?
I was not aware that there were any.
Okay. But weren't you concerned that there potentially might have happened?
I was concerned that we were in violation of the CJIS policy. I didn't think that Mr. Young had actually done any breach of any data.
Okay. And did you ever learn of him being unescorted?
No.
Oh, okay. Did you ever ask Mr. Young, what did Mr. Young tell you when you asked him about whether or not he had been unescorted?
I never asked him that question.
Okay. And were you in this pre-disciplinary meeting?
Yes, it was myself, the city attorney, and Robin Pedersen.
Okay. And did you take any steps whatsoever, you yourself, to figure out how Mr. Young could continue into that position?
When we talked to Mr. Young, there was conversations about potentially having his criminal record expunged and whether that would change the outcome. He did ask us if we could do the background check again. I had mentioned that we had, basically gone down that road and we're comfortably at that point confident that it would not pass based on my conversation with AC Sarno.
Let me interrupt you there, excuse me. The first thing, though, that I need to be clear is you explained to us that in your first meeting with AC Sarno that you never mentioned Mr. Young's name.
Right.
Okay. So that wasn't really a review of Mr. Young, was it?
No, it was a review about the process in general.
I got it.
And the
then
process in general, I mentally applied to Mr. Young's situation and made that
So
determination.
you made that determination,
Yeah.
not Mr. Sarno, right?
At a later meeting, I did ask Mr. Sarno to specifically look at Mr. Young's background check, but that was after he had been terminated and when I told him he would need to be a witness for this. And I believe those are consistent with my answers 15 minutes ago.
So it's true to say that Mr. Sarno never actually did a review of Mr. Young before Mr. Young was terminated.
Correct.
Okay. And you never went back to Mr. Sarno about Mr. Young's concerns before Mr. Young was terminated. True?
What concerns?
Well, for example, you said that he could get his record expunged. True?
True, but at that point in time, I didn't honestly believe that he could get his record expunged.
Just because you had made that decision, wasn't it?
Yeah.
So why Why challenge your own decision that you had already made, right?
No, it was more of knowing what I know about expungement. I don't think that Mr. Young could get his record expunged at this point in time.
Now, when you read the CJIS policy, the parts of it that you read,
Mhm.
did you read the part that describes this, the security officer?
The LASO,
No. The security officer.
I believe, is that the CSO?
Yes.
I believe I did take a glance at it, but didn't find it to be applicable to Mr. Young.
Oh, okay. And it wouldn't be applicable to Mr. Young, for example, if the CSO was the sole person authorized by the CJIS policy to determine whether or not somebody with a misdemeanor convictions could have access to CJIS. Is that fair?
I'm sorry, I didn't understand your question.
Oh, okay. Well, you understand
I'm
from
gonna
the
object to
CJIS.
ask and answers. It's already in the record with IAC Sarno's testimony, if we could speed it up.
We're starting to go around in circles on this.
Sure. I'll ask the question again. You understand that the CSO is the sole person, because you understand, I'll back this up a second further, that if there's a felony, then there's no discretion, but if there's misdemeanors, then there's discretion by the CSO whether or not to grant somebody access to CJIS. Fair?
I don't know that specifically.
Oh, okay.
I didn't look at felonies because Mr. Young's convictions were all they were charged as felonies, but sentenced and convicted as misdemeanors. I only cared about misdemeanors.
Totally got it. So it's the city, the determination that Mr. Young could not get access to CJIS that the city attorney relied on was your determination. Fair?
No, it was based on the determination of Milwaukee Police Department
From 2022.
from 2022. And then again, as I said, I had a conversation with AC Sarno so that I could understand what their rationale was. And I saw that nothing had changed that would make a different determination at this point in time.
You saw it, right?
Yeah.
Okay. And again, you didn't go to, yeah, okay. Yeah.
We did not rerun his background in 2024.
I understand. We can also say that Chief Sarno was never asked whether or not Mr. Young could get access to CJIS before Mr. Young was terminated. True?
I'd say that that's accurate, yes.
Okay. Did you ever communicate to the city attorney that Mr. Sarno had made such a determination?
Prior to the termination of
Yes, ma'am.
Mr. Young, no,
Okay. But you did afterwards?
yes.
Okay. Is there a reason why you waited until after terminating Mr. Young to determine whether or not Mr. Young's would fail the background check a second time?
Again, it was because I was trying to protect his privacy since we had not taken any action against him.
I understand. Did you give a concern to his due process rights at that time?
We were following civil service rules, which I believe cover his due process rights.
I understand. So it's also fair to say that none of, let's put it another way, nobody else but you, after Mr. Young had explained, after the pre-disciplinary meeting, and he explains that he could possibly get an expungement, you're the only person that made that decision that that was not going to work, right?
I also want to clarify, it wasn't a pre-disciplinary meeting. This was a pre-discharge. This was not a disciplinary termination, just so
Okay.
that we're clear there. I would not say that I am the only person who made that determination. Again, I had conversations with Harper Donahue. I had conversations with the city attorney.
Okay. And you also had conversations with Harper Donahue about putting Mr. Young on a PIP, right?
Yes,
Okay. And it's just a coincidence that approximately a month after you got this last email from Ms. Headley, that you decide to have that Mr. Young is terminated for non-disciplinary reasons. Fair?
unfortunately, it was a bad timing circumstance, correct?
Well, but advantageous for you, right?
Not really. Putting somebody on a PIP doesn't mean you're trying to terminate them. quite honestly, the problems that we were having with Antoine were things that I think could have been corrected if we had gone down the road of a PIP.
Okay. But you just didn't, why didn't you go down that road?
Because the CJIS audit came up first and we needed to address that.
Oh, okay. So at no time, it was just not possible, or I guess why wasn't this done before November 11th of 2024?
While I had received a number of complaints against Mr. Young, I did not feel that I had a lot of substantive backed up documentation to move forward with a PIP at that time. And then the CJIS audit happened, and I quickly realized that we needed to deal with that. And the only way to deal with that was through termination.
I got it.
A PIP did not seem appropriate at that time.
Are you aware of whether or not the Milwaukee Police Department has its own lasso?
I am not aware.
Oh, okay. Did you ever try to ask anybody?
I did not ask
Okay. So how do you know that the city attorney's office needs a lasso?
because it's in the CJIS policy.
And the CJIS policy requires, and I just want to be clear and we're on the same page. It's your understanding that the CJIS contract is with the Milwaukee Police Department and not the city attorney's office?
We have our own separate agreement for CJIS. The city attorney's office does. I'm
Okay.
sure MPD has their own as well.
Well, then who's your chief security officer?
I don't know.
Oh, okay. Well, so are you the one who's making sure that I mean, it seems like you're the one who's making sure that the CJIS policy is being followed, true?
Mary Lyles takes the lead. She goes to all the training for CJIS. She makes sure that people get their background checks done. She makes sure that everybody gets trained. I would say that she is our lead person for CJIS issues.
So you don't know if there's any violations of CJIS or not, you do?
I know that there were violations while Mr. Young was employed with us, yes,
How do you know that?
because Mary Lyles told me.
Okay, and what does that mean?
That means she told me that he didn't have clearance. We talked about this already.
Sure, but okay, great. And that's also, you said that he didn't have clearance, but we're clear then that he also didn't have unescorted access. True?
I am not aware of any time that he had unescorted access.
Okay. Then finally, do you believe that it would be a violation of the policy for Mr. Young to have, to be escorted in that area?
Yes,
Why?
because it would violate the CJIS policy.
It would violate the CJIS policy for him to have unescorted, or for him to have escorted access.
I'm sorry, yeah.
And that was my mistake. Excuse me.
For him, under the CJIS policy, he could only have escorted access and could not have access to the computers.
Okay. I got it. And why do you think he couldn't have access to any of the computers?
Because that is where the databases that are governed by CJIS are located. And it specifically states in the CJIS policy that IT personnel need to have clearance.
I got it. And you think, and that's for your IT, that's not for the the Milwaukee Police Department's IT, fair?
I don't have anything to do with the Milwaukee Police Department's IT.
I got it. Now, the last thing that I want to understand from you is, do you believe that the CJIS database physically resides on these computers?
Objection, there is no CJIS database. It's misleading testimony. CJIS is a policy. It's on a database.
Could you repeat the
Do
question?
you believe that the CJIS database resides on a specific computer?
If
There-
you don't,
There's no CJIS database. There are databases that are operated and administered by CJIS. I assume that's what you were asking about.
Oh, okay. And are those located on the specific computers at the Milwaukee, at the OED?
The access to those databases is available on the computers in our office at OED.
Okay, so anybody goes on those computers, they have access to that database, true?
Not necessarily.
Oh.
You do need to be able to log in. However, under the CJIS policy, nobody can even access those computers without CJIS clearance.
Where does it say that?
I don't specifically recall. I mean, I will note that there was the ERD decision, which we had talked about as being admitted to as an exhibit here, that where a janitor in the police department who was not able to get CJIS clearance was not able to keep their job because they were actually in proximity to the computers, not even on the computers.
Did you ever learn whether that janitor had escorted access or unescorted access?
I don't know anything more about the janitor other than what's in that decision.
Oh, okay. I understand. I have no more questions for you at this time. I note that I've got to leave here in about 5 minutes, but whatever is your pleasure, I am available.
I think what I could do is ask the commissioners at this point if they have any questions for this witness while Attorney Hitchcock Cross is still present.
I have a question.
Commissioner Clary.
Thank you, President Bach. This is going way, way back in your testimony. Before we actually, yes. I understand the whole notion of escorted and unescorted access. Is it possible for someone to sign on to a computer and then turn it over to Mr. Young to do work on?
Yes, and in fact, that's likely what would happen because somebody would normally sign into their computer and then he would have to, if he was doing some IT support or fixes, they would have to be logged on in order for that to happen.
So both, I understand the escorting of him is not a violation. I mean, Joe Blow, if he had the clearance, could escort Mr. Young into the office. But if Joe Blow signs on and says, Mr. Young, come have a seat, would that be a violation of CJIS?
I believe it would.
And would that perhaps cause another discipline to happen? Or not another, because this was not disciplinary. Would that cause a discipline to happen? Potentially.
Potentially, but I think the greater concern is that it would cause us to be in violation of the CJIS policy and our contract with CJIS and would jeopardize our access to those databases that are operated by CJIS.
Okay, let me just look. I don't think I had any other questions. No, that's it. Thank you very much.
Yeah.
We, based on the comments by Attorney Hitchcock Cross, I don't think we're going to do redirect or recross at this time.
I have nothing
So
to
you
add.
have nothing?
No.
So.
I do have a follow-up on that,
On
her question
Commissioner
only.
Cleary's question?
Yeah.
Well, then if you can fit it in now, please do so.
Thank you for that. And I guess my question is, would that be a if a city attorney logs into CJIS, gives Mr. Young, says here, work on my computer, and then leaves the room? Now, my understanding is Mr. Young doesn't have CJIS clearance, right? But the other person does.
Yes,
Who would be violating the CJIS policy at that point?
both of them.
Oh, okay. So that person would have to be, if that person, I guess that's my question, if that person left the room, then Mr. Young would no longer be escorted, fair?
Assuming there's nobody else there, yes.
Okay, and you trust your city attorneys under your supervision to follow the CJIS policy, true?
The attorneys that are under my supervision do not use the CJIS databases, so I can't answer that question.
And then I may have misspoken. I understood you to be head of HR for the city attorney's office, so that was my, do I misunderstand you to be supervising, at least in an HR capacity, the attorneys as well?
I am-
Something else?
I was acting HR administrator for a
Yeah.
time. I no longer am. So currently I do not supervise anybody that has access to any of the databases that are covered by the CJIS policy.
Okay, and I don't want to get very far into this, but when did you stop being?
Last Monday, I believe.
Thank you. Okay, then, while you were however it is, your capacity to these attorneys, would you expect them to not allow somebody unsupervised access to see this data?
As the HR administrator, I did not supervise attorneys. The deputy city attorneys supervise attorneys. Julie Wilson is the deputy that supervises the lawyers in the OED office.
I understand. Just if you did such a thing, would you consider that to be a violation of the policy that you signed?
Yes, I already answered that.
I understand. Would you expect that you would be personally disciplined for that?
If I did it?
Yes.
Yes.
And again, just to be clear, there's no evidence whatsoever that Mr. Young ever had unescorted access to any CJIS material.
I am not aware of any.
Thank you.
Then I take it that, since we've had the questions by the commissioner and we had the follow-up on the one commissioner, that then, we've concluded the testimony of this witness for this hearing.
My understanding, we don't intend to call her back.
Okay. Then, is it fair to say that you're now going to take care of this other matter?
Yes, please.
Are you, you anticipate coming?
But at 3:20 at the latest is
Oh.
my anticipation.
All right, then we'll take a break until 3:15 for the rest of us.
Thank you.
And
Thank
we'll await Attorney Hitchcock Cross to join us, hopefully a couple minutes after that.
Thank you.
Thank you.
Procedurally, am I still sequestered?
Uh,
No, I'm just asking if I'm still sequestered as a witness.
Since
Can you
she,
stay in?
since she's testified, would the sequestering apply? Because I did sequester.
Yeah, she has been excused from all further testimony as long as perhaps an admonishment that she not discuss her testimony with any other witnesses, but there wouldn't be any reason to sequester her further because it can't possibly influence her further testimony.
I saw. On my behalf, Mr. McLean has informed you to don't discuss it with anyone.
But
Because
she could stay in the room if
But
she chooses.
that's the answer that was given, is that, and because she was the personnel office, in effect, the personnel officer for this transaction, she's welcome to stay.
If you want.
Mr. Young,
Speak or say anything,
what?
I'll just speak or say anything in this process,
Yes, but not at this time and not when you're
but
not.
I understand
Not being
that.
represented by your attorney.
But if I wanted to say something, am I allowed to interject? That's what I'm asking.
Why don't we
Did you say
wait, why don't we wait to discuss that until his attorney is back and we're on the record?
Thank you.
Like doing business.
Yes, I guess.
I'm trying to say. What?